recently, in July, the courts here in Lee, Collier, Charlotte, Glades, and Hendry County came out with a new programs related to foreclosure and possible mediation. Can you tell us a little bit about those programs and what they mean?
Yeah, it's derived from the recent Florida Supreme Court determination that mediations need to occur and ruling that mediations need to occur in the overwhelming dockets that the state courts are facing with these foreclosure cases. And the intent is to try to get the borrower and the lender together and try to work out an amicable solution, such as a deed in lieu of foreclosure, a short sale, a loan modification, whatever the case may be, something to get it out of the court system and see if the parties can resolve the issue on their own. And it brings up an important point that when you say you're fighting a foreclosure, the bottom line is the money is owed to somebody. So you're never going to really, if you owe the money, get a house for free. But at the same time, if you can come to the table, you have the right party to deal with, maybe negotiate a solution that is workable for you to keep the house and for the lender in order to keep the loan active and allow you to keep paying to stay in the home.
And that's a big thing that David touched on there, was to making sure it's the right party. I think that's probably one of the biggest things that you look at when you get a foreclosure case, is a lot of times the people I've talked with, they get a foreclosure case and they don't recognize the name that is the plaintiff in their foreclosure case. And one of the things that we try to do always is examine the documents to make sure that you're negotiating with the right party. And then the other thing that a lot of people tell me is they've been contacting their mortgage company for months, years even at this point, and they keep submitting the same documents 5 and 6 and 7 times, and they haven't got a response. Will this program help to alleviate some of that? I call it beating your head against the wall, but will this program help to remedy some of those situations?
We've seen that it has been helpful in the preliminary stage. I mean, mediations are nothing new to the foreclosures. Ever since the order came out, we've been attempting to get the court to just compel mediation in individual cases as appropriate. This new mediation program is actually a circuit-wide for the 20th Circuit requirement that mediation has to occur in every residential mortgage case when the borrower elects to participate in it. So it's essentially saying that every case has to have a mediation in it before it can proceed further and get to a final judgment. What's going to happen is in the mediation order, it's stating that the borrower has to appear, the plaintiff's attorney has to appear, and then the plaintiff can either appear by phone or in person. But in any case, whoever is appearing as the representative for the plaintiff has to have full authority to settle the case. And what that means is they don't have to go back and check with anybody on anything. They have the power right then and there to settle a case for whatever they deem appropriate.
And one important thing to note, though, is just because you make a phone call to the mediator that's on the back page of the lawsuit that you got, that doesn't absolve you of the requirement that you file an answer in the case within 20 days. So just because you called the mediator doesn't mean that you don't need to still respond to the lawsuit, because that can still go forward.
On a second note on that, though, however, the party, if you haven't filed your answer and it's been more than 20 days, they cannot default you under this program until the program has either been deemed that you are not participating in it or the mediation has completed. So if it's over that 20 days, you can still get that answer in before they can default you and protect your rights in that case.
One of the important things to think about, though, in this situation is what do I do with my second mortgage? If my first mortgage is foreclosed on me and I've done the mediation, does that automatically take care of my second mortgage, or is now there something else I should consider with my second mortgage?
There's probably something very well you have to consider. It goes back to the whole line of deficiency. Whether you want to keep paying that second mortgage, that's always an option, of course. Or you can go back and have a whole plan to reevaluate your situation, and it could involve some type of mediation of the foreclosure on the first mortgage to get a modification, and then followed up with a bankruptcy, whereas if the first mortgage value is less than if the home value is less than the first mortgage principal balance, the bankruptcy in Chapter 13 has the potential to strip off that second lien on the house and leaving you only with the first mortgage as modified.
So when I go to a mediation or something under this program, it's only dealing with my first mortgage, and it doesn't solve all my problems. I still may need follow-up or something of that nature. Is it possible to have your second mortgage go into a file of foreclosure against you?
It is possible. Whether it's likely or not right now, it's more likely that they would sue you on the note, which is the obligation to pay, as opposed to doing a foreclosure, because if they tried to foreclose on the property, there would likely be no proceeds above and beyond the first mortgage, so they would have done a lot of work and got no money for it to show, so to speak. But in a mediation, you know, it doesn't necessarily mean it's going to resolve favorably. I mean, you could come to an impasse at the mediation and nothing could be resolved. So yes, you have to always think about what happens next after the mediation if things don't go the way you're hoping to go. But the second mortgage is able to appear. Sometimes they do appear, and they can take a token settlement. For instance, what happens lots of times in short sale cases where the first mortgage will throw them a $1,000 concession to release their lien at the sale, and then they're off the property as well, and then it's just a matter of how are they going to treat the unsecured deficiency balance.
And one of the things to remember importantly, as we talk about foreclosures, and it also relates to short sales and things of this nature, there's a big difference between just releasing the lien and resolving the debt. A lot of times I see these short sales where the first mortgage holder says, we'll contribute $6,000 to help you release the lien on the second mortgage so that there's clear title. Unfortunately, a lot of times that also means that the second mortgage company is getting their $6,000, but they're retaining the right to come after you for the difference. Now, oftentimes, like Mr. Feynman said, this is done as an action on the note and not actually as a foreclosure case. That brings it out of this kind of mediation aspect into just your normal lawsuit. And we can kind of tie this into, it's almost like a credit card. It's a big credit card. And what are some of the things that you should do if you get either a credit card lawsuit or one of your second mortgages coming after you?
Well, like any other, I mean, a lawsuit is a legal proceeding, like any other legal proceeding. It's always best to consult an attorney about it and what your rights are. Again, bankruptcy may be the option, maybe it's not. There may be other options that are available to you, but each case is very different, very specific to the facts that are in it, and it's very important that early consultation in the beginning of the case is done in order to know what your rights are, where you want to, what rights you want to assert, and of course always do a cost-benefit analysis as to which way you want to go with the litigation of the matter.
And kind of along the same lines, we got a call from Penny this morning, and it said, I recently got married. At the time we got married, my husband already had his house, and now I've been named in the foreclosure lawsuit. Am I responsible for the debt on my husband's house?
Well, if I understand the question correctly, is that you did not actually sign when the home was purchased. So you're not on the note. You're not obligated on the note at all. Many times this happens, especially in the state of Florida, because the homestead is a very highly guarded, protected interest in the state. One spouse cannot convey away the interest of the homestead without the other spouse's consent. The mortgage is a conveyance of an interest in the home.
And when you say, just to be clear for our viewers, when you say conveyance, you know, that just means that you're transferring something away, that one spouse can't give away the house without the other spouse's knowledge. So, you know, when you talk about the term convey, you're actually talking about transferring the title or something of that nature.
Yeah, that's exactly right. So basically, in order for the mortgage to foreclose on the house, they have to serve all parties that have an interest in that house. Now, if you weren't married before the house was obtained, then you got married knowing about the mortgage, so the mortgage is valid. But they still need to serve you with that lawsuit, because if they're going to foreclose on his interest, they can take his interest away, but you still have an interest in that home unless they were to foreclose your interest out as well.
So I guess if you could sum up it, would she be liable for the debt? You know, if she hasn't signed on the mortgage, does she have responsibility for the debt, or is it just a matter of that they're foreclosing her interest off the mortgage.
Yeah, it's just the interest on the mortgage. If you did not sign the note, then you are not obligated on the obligation. And it's the same thing for credit cards with the if you're an authorized user and did not sign to be obligated. In most cases, you are not obligated on the balance. There has been some case law developing where authorized users may be responsible for charges that they have made on the account if they sign the receipt, if the provisions are in the agreement to say that. But there are defenses that can be raised to that issue. But it's something to definitely be concerned about and look at before you make a blanket rule that you're not responsible for it.